not secured, but the denial of rights of others. Good afternoon to one and all present here. I, Avya Arora, am your host for the day. Center for Legal Studies, Geeta Ratan International Business School welcomes you to the PD workshop on Interpretation, Interaction and Improvement, Latest Judgments. Center for Legal Studies, Geeta Ratan International Business School, headed to Guru Gobind Singh Indraprastha University, Delhi, and is approved by All India Council for Technical Education, Ministry of HRD, Government of India for Technical Programs, and Bar Council of India for Law Programs. The institute is conducting postgraduate programs like MBA, MBA International Business, and undergraduate programs like BBA, BA LLB, and BBA has been ranked second amongst the top B schools of North Delhi in Times B Survey School of 2018, 2019, and 2021. In the world full of rights, freedom, duties, we all are surrounded by law everywhere. So, to unleash the three aspects of interpretation, interaction, and improvement with reference to latest judgments, we have among us Justice Mohan Sharma sir. Sir earned his degree from Delhi University. He has completed LLM in cyber law. In 1991, he started his legal career. Sir joined the Nationalized Bank as a law commissioner in 1994 after 3 years in practice. In 1997, he quit and returned to practice. He explored while in practice and worked as a lecturer of law of faculty, University of Delhi in 1998 on 2003. In 2007, he became an additional district judge with Delhi Higher Judicial Service. In 2020, he has served as district judge and commercial court. He has completed training as a mediator and a trainer. So has reached a milestone by providing training to over 1,000 people across India. Not only that, but also Sir is a computer master trainer. In addition, he has written a number of articles on variety of topics. He is truly an epitome of knowledge. We welcome you here, sir. The virtual stage is all yours.
Thank you very much. I don't deserve all the applause that has been showered upon me, but I treat that as a compliment and way forward. I hope that I would be able to achieve the things which you have mentioned. Life would give me an opportunity and maybe most of these things would be fulfilled. I disclaim that I am a person with so full of knowledge that I can bestow that knowledge upon others. I am an ordinary human being. I would share my side of the views on the subject, but I am not the last word on it. And for that matter, I would say that nobody is the last word on it. I am very happy to be here amongst people who would tomorrow occupy their valuable places in the field of law, whether as judges, whether as teachers, whether as advocates, whether working with BPO, or in whatever manner they may enrich the field of law. I am thankful to the institute which has carved a place for itself in this era of competition, and the entire team which has made umpteen progress. And I have been associated with Geeta Ratan Jindal Institute in more ways than one in the past, and hope that the association will continue in future also. My all good wishes for the progress of this institute and all the people who are connected with it, whether as a resource person, whether as a teacher, whether as the management, as student, in whatever way, I hope that they would serve the society, contribute, pay the social cost which we are all supposed to pay because this society has given us so much. Today, we are at certain kind of crossroad, especially in the field of the law and judiciary. It is not that we have come to crossroads for the first time. This keeps on happening, but thanks to the technology that we have come to a stage that what was once upon a time a confine of only limited few has become household names. People have been empowered through technology to disseminate information and knowledge, to discuss the issues which were earlier thought of as belonging to a select class. So, in this backdrop, may I request the administrator if the sound can be controlled? Because I experienced some lot of noise from the background. Thank you very much. Thank you. I'm audible? Anyone can answer?
Yes, sir, you are audible.
Thank you very much. Thank you. You see, law is nothing but what the people wish and achieve for themselves. Nobody can give anybody justice. No society can remain in a stoic position, keeping its fingers crossed, waiting for justice to dawn upon it. It is a mission which has to be achieved, and in this mission, all and sundry, they have to be contributors. We can contribute. It is not that a teacher in law cannot contribute. He contributes by the way he disseminates knowledge, implore people to explore the law, to achieve justice for people. A paralegal person who is helping people to know about law is also contributing. A person who moves to the highest court by way of a PIL without even sometimes the aid of a counsel is also contributing. In small measure or in big measure, we all contribute to the development of law, and this is what is the dynamics of law. Justice does not come to people. People have to raise themselves to justice. With the change in thought process, change in aspirations, change in the needs of the society, new challenges may come. Challenges do not make or mar us. How we face the challenge, that makes all the difference. What kind of law thinkers, what kind of advocates, what kind of teachers, what kind of judges the society has created, that makes all the difference. There is no future. Future has to be discovered. Future has to be created. Sometimes what we perceive as a trouble is a step forward in the right direction to make us, to create new opportunities, to find a solution where the people have stated that no, we are at the dead end of the road. It is our thinking capability, whatever the mind can conceive, it can achieve. We are a democratic country and the biggest democracy of the world. We have let the democracy survive for so many years. By our small contribution, maybe as a voter, maybe as a person who plays Nukkad Natak to bring home the message, maybe when we get together, when Nirbhaya case was there, we proved ourselves to be the harbinger of change. So it is thinking, maybe when you think of an idea, society may not accept it at once. You are perhaps on the wrong side of the way on which the people think. You are on the wrong lines. You have conceived of something new, which is perhaps shocking for people. People don't think in those terms. I have a friend in a foreign country, and he asked about how marriages are happening in this country. I told him that mostly the marriages are arranged by parents or guardians. So it was a shock of life for that person that the marriages happen like this. They say that here the prospective matches, they somehow accidentally meet each other and then it converts into a marriage, may not convert into a marriage. So it was totally shocking for that person, but it is well accepted in our society. After having our constitution and more than 7 decades having passed, this is the time for introspection, where we have gone, where we have reached, and what else is to be traversed, what else, what other horizons are open to us. Freedom not only of eating what you want to eat, going to the place of your choice, or some other things, are just the freedoms which even an animal can enjoy. But we, being humans, have much more on our platter than an animal can have. I don't say that the rule of jungle is bad. Rule of jungle is not bad. It is the rule which is created by nature. Big fish eat the small fish. This is how the nature takes control of population, nature takes control of the resources, nature takes control of our very existence. But in this process of existence and fighting for existence, the fish has developed a particular kind of body. Fish has developed a way to escape predators. Fish do not use treadmill, do not use a cycle to exercise. The nature has given them enough threat that they can achieve they can survive, and they can prove that Darwin was right when he said that it is survival of the fittest. But as human beings, we have gone much farther. We have developed a way of living where it is not only the survival of the fittest, it is the survival of the sickest also. We help people survive who are born with certain diseases which make their survival difficult. We understand that somebody has to use the wheelchair, the society provides for it. The accumulated resources of the society are used in a manner that the government will take from those who have and would provide for those who don't have. We have developed the concept of social justice, which, though the rule of jungle being the nature ordained rule of existence, we have improved upon it. We are not gods, but we have done certain things which even God has not done. It is not that God is wrong. It is not that God does not have a plan. God has his own plan, working on it. But we as a human beings, because the God has blessed us with intellect, we have tried to create a brave new world, a different world where even those are taken care of who don't have means at their disposal. We fight calamities. Animals do not do any such thing. They just succumb to the calamities. They just come to the pandemics. But we become wiser with every challenge we face. And these many challenges have been faced in the field of law also. Thanks to the contribution of the law teachers, thanks to the contribution of the people who raised their voice despite all odds against what they thought is not right in the society. They became the harbingers of change. Thanks to the judiciary, from the highest echelons to the subordinate judiciary, that they were able to think in a different manner. They were able to conceive the ways. They did not only suggest the problem, they suggested the solutions also. And many of those solutions, they are reality of today. We are having a society governed by rule of law, thanks to the person who had fought for this. Thanks to the activists who have achieved this for us. And we know that this is not the end of the matter. The horizon is yet getting wider, yet getting far off. We have traveled a long distance, but we have go a long way to achieve so many things. We have not forgotten our history. When you are taught legal history in a stream of law, when you are taught about sources of law, that is not end of the matter. We remember history so that we do not repeat the mistakes which brought certain calamities upon us. We remember history so that what is good is followed and sustained. We remember history so that we create a new history. We remember history so that whatever was good earlier is made better, and whatever has been made better becomes the best. It is that common endeavor which our constitution has given us. Maybe in the form of fundamental rights, but our constitution was very conscious that rights are only one side of the thing. Ultimately, we may reach a stage where duties would be equally shared by people. That's why the Constitution of India has provided for duties, the aspirations which the Constitution expects from the people. And we are moving towards that direction. Besides law, besides fundamental rights, we knew when we had awoke to the freedom of our nation that our resources are limited. So we had our priorities, but our vision was not limited. The framers of Constitution provided for the directive principles of state policy also, so that when we reach that level, when we have taken care of roti kapda or makan, we can move to the higher status. That is what. And in this endeavor, the framers of our Constitution, they had a great vision. No person who was not having that kind of vision would have created this masterpiece, which we call the Constitution of India. Wherever there have been any faults, any shortcoming, we have failed the Constitution. The Constitution has not failed us. So when we look into the how the legislature thinks, when we look into how the executive works, and when we look into how the judges think, how they contemplate, how they interpret the things, what tools are available to them, who controls whom, or whether everybody is independent. There is no prime wheel. Every wheel is the prime wheel. It is moving the nation forward. Our ethos, our philosophy of life, our values, then we will feel that there is no prime wheel which moves our nation forward. There are three wheels which work in tandem without encroaching upon the territory of each other, and wherever sometimes there appears to be an encroachment or there appears to be some deviation from the path, we correct ourselves. We have that healing power within us. Sometimes it may happen that it may appear that one particular organ of the system is moving faster than the remaining two organs, or is trying to eclipse the other organs. These stages do come, but we have inbuilt resilience in us that the system corrects itself. We replace the government which is not working by exercise of our franchise. Judges, maybe it may be a difficult process, but the Constitution provided for impeachment. Legislature, if the law is not good for the society, people do not hesitate to come to streets to voice their concern against those things. So it is always our contributory process. I may be a very small citizen, but I don't believe in inertia. When I say I means everybody. Everybody who is concerned for this nation. We know that we have limited resources. We know there are certain powers in the world who are governing the system and trying to encroach upon the resources of a nation. We know there are forces who want to annihilate certain countries from the world map. But our metal is made up of such thing. Thanks to our three institutions, thanks to each and every citizen of this country, that we can think beyond limitations. We can think beyond scarcity of resources. We may go wrong once, but we also go right 1,000 times. Through legislature, we bring the will of people. Through franchise, we elect the people who would be our representative, who would be governing this nation. And through our judicial system, we can take care that wherever there's an issue, wherever there is a roadblock, sometimes the issue may be between two persons or a group of persons. So we have room for adversarial litigation. You agitate your case, people would be heard, all who are stakeholders in that issue, and ultimately the justice would prevail. But we did not stop at that. A time came when the courts realized that yes, it is to provide succor to those persons who, for want of resources, cannot approach High Court or Supreme Court. So just a simple postcard had been treated as a writ petition. It was because the judiciary was conscious. It was because the judiciary was concerned. It was because the judiciary was dynamic. We, at the cost of repetition, we look into the history, not to just to speak of the laurels we have achieved, but we also look at the history to find out that past laurel is past laurel. We have to earn new bucks, we have to earn new responsibilities. So maybe whether it was oleum gas leak in Delhi, whether it was Bhopal gas tragedy, whether it was the protection of national monuments or heritage places, somebody took the call and courts were not found wanting, because our courts are dynamic, our courts are independent. You see, you cannot leave everything to legislature. Legislature becomes conscious of a thing, it takes its own time. Once the problem is there, the problem of female infanticide had existed for a long before it became so alarming that a law had to be brought. But we know there's a time gap. But the courts, realizing that this time gap cannot make people wait for the law to come so that justice is dispensed to them. In Vishakha case, the court took the first step forward. There was no law in existence on the aspect of the sexual harassment of women at workplace. The court took the initiative and filled up the gap that yes, legislature will take its own time. It has to pass through a consultative process. It takes its own time. So let us fill the gap. And it prepared some model rules. And ultimately, the law on this aspect was in place. Nowadays, it is our obsession with written words. Therefore, the common law has paved way for statute law. We want our rights, our remedies to be written in black and white through an act of parliament, through an act of state legislature. So we have the statute law here. So many torts of negligence and causing an accident, we have Motor Vehicle Act. You are passing off your goods as mine, we have Trademarks Act. You are copying my literary, dramatic, or artistic work, copyright law is there. So many torts have crystallized into statutes. Statutes, they were part of solution, no doubt, but many times they become part of the problem also. They are part of the solution that everybody should know what are his rights. They are crystallized in word. Though Section 9 of Code of Civil Procedure only talks of any civil right. It does not talk of that any civil right which has been crystallized by the statute. It talks of any civil right. It is not a limited thing. It is unlimited possibility. But the statute law, though it crystallized the things, it created certain problems of its own, because proof of pudding lies in the eating. Sometimes, despite the best of the intention, some errors may creep in by virtue of certain punctuation, certain use of words. So many 1001 reasons. And when these are confronted, when the courts are confronted with the same, the constitutional courts, they sometimes declare a statute to be ultra vires. Sometimes they find some fault with the punctuation, which is creating some problem of interpretation. So they go beyond the normal rule of thumb thinking. They have many tools at their disposal, which have been classified as rules of interpretation of statutes. There are so many things: golden rule, literal rule, mischief rule, rule of adjustum generis, nocere socis, use of punctuation marks, use of title, headings, notes, illustration. What are their respective potentials and what are their respective limitations? This has not been given to us by a statute. This has all developed with the wisdom over the years, which, thanks to the authors also, I had forgotten them, they have also contributed in this. They have assimilated the knowledge, presented us in the short form, and thanks to Gutenberg also, who invented the printing press, because otherwise law would have been the property of only a limited people. It's mass printing. You see, setting up a printing press at that time was a very costly proposition, and he in fact paid for it. But today we are here. Otherwise, I tell you, the book which you buy for 1,000 rupees and sometimes you bargain for discount, maybe you get 20%, 10%, 15%, 30%, would have in fact been taking years for production and a very costly affair. But people have contributed in many ways. In law, people have contributed. It is not that the law is the repository of judges or parliamentarians. Law is the contribution of all people who raise questions, all people who demand, all people who tell that there are other ways of thinking also. There are other ways of going to heaven, or sometimes hell is a better place than heaven. People who think with some different perspectives. People who challenge the established practices. People who challenge the dogmas. People who challenge the thinking, which, because we have been so accustomed with it over a period of time, that we think that this is the only way. So, if you want to make a difference, you have to make yourself a different person. The judges, through their judgments, they have conveyed the social thought process. They have brought changes. They have interpreted the law. They have, what was a dead letter, they have made it a living testimony. So what is required? What is required, if I borrow the words from our president, APJ Abdul Kalam, what is required is ignited mind. A nation which does not have ignited minds is dead. A nation where everybody conquers, where everybody agrees to the high and mighty, is dead by all standards. Nation which keeps the debate alive is always moving towards progress, moving towards achievement of the next best thing, because best is not the end of everything. After best, there is next best to be achieved. So it is only the thinking process. What we have gained from our ancestors, not buildings. Buildings come to an end. Some monuments may survive for 400 years, 700 years, 1,000 years, but they have to kept in good repair. What we have borrowed, what we have inherited from them: gold, silver, artifacts. These all things vanish. What we have in fact inherited from them, it is what written in our books. Maybe I may not agree with Karl Marx. Maybe I may not agree with Hitler. But I know that Karl Marx was there in existence. Karl Marx is not a person. Karl Marx is a way of thinking. Hitler is not a person. Hitler is a way of thinking. Whether those were right or wrong, if we can analyze that, if we can enter into that debate, that by itself states that we are sufficiently armed. We have the resources at our command, because we can think, we can debate, and our system accepts it. Our system does not suppress debate. Had that been so, we would not have been able to utter even a single word against anybody who makes a meaning to us. But every day, and now we have been much more empowered thanks to IT, that we have the WhatsApp at our command. Much cheaper than the book. Of course, I'm not against the copyright interest of the authors, but whether fake, whether stolen, whether copied, knowledge is there in dissemination. We learn, we enjoy, we know that, and every day we argue that most of the information on the WhatsApp is fake, half-baked, untrue, but yet in the hope that something true may come. And even if we want to know the truth, we must know the falsehood also. It is only by contrast that we can learn what is truth and what is false. So every moment we have a debating mind. It is good. After that process, our brain evolves and may create a new thing. I may drop an idea somewhere. Somebody may agitate upon that idea and may come with a new idea, a better idea, a workable idea. So we every day we interpret the things. Judges also do the same thing. They have certain rules at their command, which we call the rules of interpretation of statutes. They have a vision before them. They have the law with them. They know that where you have to go by the rule of law, by the book of law, and where you can move to the next step, that you don't tear down the book of law, but you move forward with the same law, making it a living legend. Law is not for dead persons. Law is for living beings who are governed by it. Even dead are also governed by law, because even once a person is dead, it is not that he is completely annihilated. He had a philosophy of life that is there in the form of his diary, his writings, the books. He had a certain reputation which is carried over generation. With how much goodwill and reputation he started his life, and how he has made that impoverished or enriched that, that is also his contribution, which would continue for many generations to come over the ages. So this is the dynamics of law, which is keeping us alive, making us move forward through our robust judicial system, where your rights and your responsibilities are weighed in a scale which is as precise as if you are measuring gold in it. And even if there may be some fumbling or falters, the system is built up in such a way that the checks and balances are there in place. One court may error, there is higher court to take care of it. Supreme Court also says that we are final because the buck stops there. But it is not that we are always right. And many times, Supreme Court has revisited its judgment by a higher bench to correct the inadvertent errors which have crept in the system. And even in the rules of interpretation, we can say before this same Supreme Court that this judgment is wrong, or some judgment has been passed, not taking notice of that this similar judgment by similar strength of bench on the same subject, this has not been taken care of. All these powers we have given to ourselves. Our system is propagating those rights and responsibilities. We do not only support the person who is high and mighty, rather we always stand for the person who is underdog, who is being bullied, who is being taken for a ride, who is being suppressed. It may take its own time because it is our system. We cannot crib our system. We can only help make our system improved, better, next best by our whatever smaller contribution we may give. I heard one story that when the Ram Setu was being built, by Lord Ram. Then there was a squirrel who also contributed to that in a small way. She used to dive into the earth, the dust which was lying there, and then get rid of that on the setu which was being built so that it can make the road smoother. Once a child saw that the sea, because there was turbulence, has brought with it so many small fish. And when it went back, the waters receded. Those fish were gasping for air to breathe. So he took one fish and threw that into water, another fish, another fish. So his mother asked, there are so many fish which have been brought with water. Do you think that you can throw them all into water and make any difference to them? The child picked up the next fish. He said, I don't know whether I can make difference to them, but I can certainly make difference to this small fish. So this is what our endeavor should be. The constitution is not, the law is not to be taken care of certain persons. It belongs to us. We have to make it alive. We have to make that, yes, we not only enact the law, but we follow it, we meet it. Somebody said that if you make yourself a good person, you would be sure that at least there is one rascal less in the world. So I say the charity begins at home. If I wake up in the morning and throw my bag of garbage on the street or before my neighbor's house, if I refrain from doing it, there has been some compliance of law. So small things make a lot of difference. Think, contribute, look forward, would bring a positive way. Everything is not to be done by police. Everything is not to be done by judges. Everything is not to be done by parliamentarians. We all have to contribute. And for that, only there is one requirement, that we should have the ignited minds. So this is small and long of what I have to say. I hope that I have been able to convey my side of the things. I don't know whether I am right or wrong in this. I don't know how much I am right or how much I am wrong, but I felt that this is an occasion where I can share this, and maybe if it makes a difference to one small fish, I'm happy. I have achieved what I wanted to achieve. And then somebody next will do his part of the job, and it would make a difference to one another fish, one other human being, one other person. So thank you very much for providing me this opportunity, and look forward that we continue with this journey. Thank you.
Sir, by your permission, can we have a photo session, sir? Abhya, can you ask all the Abhya, can you ask all the students to turn on their camera and let us have a photo?
Yes, sir. I request all the students who are there in the meeting, please switch on their cameras. Everybody, please switch on the camera so that we can have a photo session.
Harshab, Prem and Abhiya both will take peak of this session.
So I guess, Asha, are you done? So,
Yeah, we have.
so
Thank
Okay,
you very
Abhiya,
much.
please proceed.
thank you so much, sir. It was extremely valuable to be the part of this session. And I hope, like, as you quoted the words of a former president, there would be certain enlightened minds and they would be the fishes you are wanting them to be. Definitely. So, may I have your permission to take up few questions that our audience would like to be
Sure.
answered?
Though I do not guarantee any answers or the right answer, but I would give my side of view on those questions and let the debate continue.
Definitely. Definitely. So all those who are having questions may post that in the chat box.
I have certain questions which have already been circulated to me.
Yes, sir.
Some people gave their questions in advance.
Okay, sir. So,
So,
sir,
if you permit, I can take them one by one.
yes, sir, I can read that for you if you want.
Yes, you can read that, and you
Sure,
can read the new questions also.
sure, sir. So, sir, the first question is, we are in the age of statutes, and it is indisputable that the statutes are following up the common law. Yet, the study of statutes as a coherent whole is rare. So, what is your taking on the challenge of thinking seriously and at a practical level about statutes?
Uh, I think this question has an inbuilt answer also. See, for past some time, there has been an obsession that wherever you find a problem, answer that with a statute to the society. You see, it takes its own time to bring into existence a statute, but it takes much more time to show the exit door to that statute once it has lived its utility. There is a statute which has prescribed that when you go to deposit money in the bank, how much money you can give in the form of coins or change. So there is a need to change or out to this statute because with the advent of digital payments, with the scarcity of coins, it has lost its relevance. This is only an example, but we have a heap of statutes. Statute also require an audit, like a bank or a company or an establishment requires an audit every year. But this is not the practice which has been regularly followed. Time and again, off and on, sometimes the committees are appointed, commissions are appointed to look into the statutes which have lost their relevance or the statutes which require a relook, some corrections, some amendments. I think that it should be a regular process. That there is an audit of statutes. If they have outlived their utility, they must be taken off the record. Perhaps it would be the most difficult question on earth to ask how many statutes do we really have in our country. This figure, I think, anybody may reach near the figure, but perhaps nobody can claim with certainty that his answer is correct. And this is not that we have statute at the central level also, we have statute at state level also, and many statutes followed in many different states. So there is, if we want to go far, there is a need for consistent audit and there is need for reduction of luggage. If we want to go far, otherwise, with the kind of luggage which we are carrying, I think our entire bundle of energies is wasted in carrying that luggage forward and not reaching a good place where we ought to be as a very strong nation and as a very strong democracy. Yes, you may move to the next question, please.
That was an insightful answer, sir. So the next question is, how is excessive delay in granting bail was a violation of right to life?
You see, what to talk of excessive delay? The Supreme Court has time and again stated that even 1 second delay is fatal because our constitution gives a right of liberty as one of the prime rights, right of freedom. The how much important the freedom is can be realized if somebody asks you to sit in a particular room, maybe with all the amenities, for a particular period of time, maybe half an hour. You may, of your own choice, may remain at that place in that room. Maybe you are engrossed in a book for many hours because you are happy that you are free. But the moment fetters are put on your freedom, it is very difficult to remain in the same cozy room for long. So, what to talk of excessive delay, even a single moment of delay is fatal. But see, we are a dynamic society. Judges, they are also part of that society. And however best a person can be, he still has his own thinking, his own way of thinking, his biases and prejudices too. They are inbuilt by the various circumstances. If as a child, when I was only carrying 50 rupees in my pocket and going for a picnic, if my pocket had been picked, that would leave a very deep scar on my psyche. And maybe if tomorrow I am sitting as a judge, it may come in the way of my thinking, and I may be very harsh to a pickpocket. And maybe I may not be that harsh to any other person charged with some other crime. Plato, in his book, The Republic, has talked of philosopher rulers. You see, earlier the king was repository of law, administrator, warrior, general of army, everything. As we developed, we had put in place specialized people. Army has its own different journals. The nation has administrators like prime minister, president, cabinet ministers, MLAs, MPs. Police has its own system. So all those duties and rights which were only encapsulated in one king, they have been distributed to various specialized people. The best way to come out of this aspect of delay in granting bails and how to have a balanced approach which is more or less universal across the board. We need to look towards our law schools so that we develop in the people who go to man the offices as a judge, adorn the seat of a judge, to have, we need to have a policy, not statute. I'm not asking for statute, because if we enact a statute, then it is not that this task can be assigned to computer, that you put a bail application and 1001 factors, and those factors are fed into computer, and it may yield certain kind of result. We need to make our judges, and that has to be done at the school level, college level, when they come and in future they would be going to occupy the seat of a judge, to develop certain kind of rationale so that whenever any judgment, any order is passed on bail, society would say, yes, this is right. Majority of the society, because we need dissenting people to make us to the next better level. So that should be there. And in many nations, during 5-year study of law, 4-year studies of law, 6-year study of law, they branch out in the 3rd or 4th year, whether you want to go to join the profession as an advocate or whether you want to join the profession as a judge. And then there is a small difference in the way they are imparted knowledge. You see, advocate, the counsel fights for the cause of his client and many times oblivious of the interest of the other party. So between this tug of war, the judge has to come clear how to balance the interest of the society, how to hear the persons who are voiceless, to hear the unheard. So there he can balance that right, that yes, you should not remain in the jail any longer than that is necessary, and that yes, victim is also provided his succor, society is saved from the persons who are a threat to society. So this requires a very fine scale of balance. So some teachers and universities, law colleges, they have to play their role well on a macro level. Otherwise, the debate may go on. You can move to the.
Yes, sir. So that was a very practical aspect of justice delayed is justice denied. And that was a very apt answer. So the
There's
next
other
question.
side of this. Sorry, I just want to. Justice delayed, justice denied is one concept, but justice hurried is many times justice buried. That is also other side of the coin. It is very difficult to maintain that balance, but when faced with the task, we have to manage it. I can't say that the bias can be ruled out or prejudice can be ruled out, but it can be kept at the bare minimum. So that should be our endeavor in our teaching.
Definitely,
Yes.
sir. So, sir, the next question is, center keeps on emphasizing not to criminalize marital rape. Why? How will criminalizing marital rape will not support the reason given by the center?
See, this matter is before court. The court has felt that it is the executive, it is the government which has a wider consultative process. The law is not that center wants it or center does not want it. The law is not that somebody has moved the court that this should be there. And that is a brave act. Law is not to reward that brave act. Law has to be thankful to that person who has put this debate, who has taken the first call on this issue. But the courts know that what are their boundaries. Who has to be heard? Courts do not interfere in policy matters. If the courts are confronted with a statute, having something or wanting something, the courts hear all concerned and then may declare a law to be ultra vires. Or if the court finds that yes, something ought to be there is not there, government is made conscious of it, legislature is made conscious of it, and they can take their own call. That is what the law, the constitution expects, a kind of discipline from various organs of the state. Courts understand this because time and again, if you read the judgments, courts have emphasized this thing that these are my powers, and with powers come the responsibilities. I must be very careful that I don't transcend my limits, I don't transcend my discipline, I don't transcend my responsibilities. I take more and more responsibilities, but taking up responsibility does not mean that I eclipse some other organ of the state, which is to be primarily. Whatever is happening for good. A debate has been made. Press is also taking, though press has not been stated formally as one of the organs. But if we look at Article 19, a lot of responsibility has been put up on the press. Social media has removed the print media and electronic media to a certain extent. It is generating its own debate. This debate is good for the society. This debate, whatever may be the outcome, this debate may bring out good results in empowering certain sections of the society which have been not given those rights which they naturally had. So this debate, I'm sure the courts are seized of it, would lead us to certain fruitful things in this regard. So till then, till the courts take their call on this subject, let us keep our fingers crossed, watch the debate, and see what comes out.
Definitely, sir. We totally agree that healthy debates definitely give good results. So, sir, the next question is statutory interpretation best understood as seeking to affect the intention of Parliament, or is that is an unhelpful fiction?
See, the intention of Parliament is reflected in so many things. The preamble of a statute, which we not always read, because I know that if I have to stake my right on a certain section of the statute, I have to do more and more work on that statutes to understand where I stand. But when we are stuck up, when the language is not clear, when it is going this way or that way, the intention of the legislature, the intention of the parliament is very important. But the question here is from where to understand what material is there before me to understand the intention of the parliament. So there are many ways the parliament expresses itself in the words in which this statute has been enacted. And the general rule is the literal rule, or the next best is the golden rule. How to go into the mind of the parliament? You see, somebody asked whether Google is the most intelligent person on earth. I said it is the most confused person on the earth because it knows pros, it knows the cons. It has got no final mind. It has got only views. This side of the fence, that side of the fence. What is the intention of the parliament? Whether it is the majority which reflects the intention. Maybe a person in minority may have very good point for consideration. But even if somebody wins by one vote, winning is winning, nothing succeeds like success. It is a very good tool, but cannot be stated to be the perfect tool because, see, this is a process. If I'm reading the intention of the parliament through various parliamentary debates, through whatever has been written in the society, there's a chance that my own views may get merged. See, whenever somebody praises you, you feel very happy despite knowing that most of it is false. And whenever somebody speaks ill of you, your normal reaction is to react. Reaction is to react, to dislike. Though the person may be your very good friend and is trying to reform you. So it is very easy for any mind to accept whatever fits into his idea of the things. This is very difficult to find out even for the person who is into this analysis. So intention of parliament, the best thing is to read the statute as a whole, to read the preamble where the parliament opens up its mind that what is the objective. But again, we are all victims of communication. Sometimes we may think very good, but we may explain in very poor terms. It's draftsman error which creep in. So this tool is there, has been often used, but cannot be stated to be a rule of thumb which would always come out to be perfect rule. It has its own pitfalls which have to be taken care of. So that's my take on this particular question.
This is a very valuable insight, sir. So next question is it constitutional to enact interpretive rules?
I think sometimes some things are very good if they're left to themselves. If you try to make everything, put everything in a straitjacket, it may create more problems than it may solve. It would be very good if the rules of legal interpretation are brought in the form of a statute. There would be more discipline in understanding the rules and interpreting the rule, but that would also stifle the growth of this jurisprudence. Because we have rules, so we are bound to follow them. And ultimately, we become victim of the rules. Somebody said, rules are for the fools, wise men make them, wise men break them. So having a rule at that time, at the contemporary time, may be very good things to start with, but ultimately, it would not let you think out of the box. Your thinking pattern would revolve around those rules, and it would take out the very dynamics of law out of it. And though the beginning may be very good, but ultimately it would be a recipe for disaster, would not serve its real purpose, would make the growth of law within certain box and not out of the box. That is, I say that if you are in a rat race, maybe you may win. You may be declared one of the best rats, but you will still remain a rat. So this is the kind of thing which would fall into our lap if we take this kind of approach by putting the river between two banks. River has two banks, but still in Hindi it is called Nadi, Nadi. So with two banks, it is still poor. That's why many times river break their own banks. They change their course, they change their route. Let the things grow. If they can grow on themselves, let them not put into a place where they cease to grow. You can move on to next question.
Thank you so much, sir. That was very observant with the nature as
Yes.
well, and
Abhya,
nature as
Abhya, now we are having very less time. Abhya, can you hear
yes,
me?
sir.
Now we are
So let
having
us
very
Yes,
less
sir.
time.
let us
So
take
please
the
ask
last questions.
last question. Please ask last question. Okay.
Yes,
Yes.
yes.
Okay, sir. So, do you think that the golden rule of interpretation overlooks the need for improvement of legislation?
It may be so. I'm not denying it. But you see, sometimes we know that inflation is bad. We also know that deflation is bad. And if we have to choose between two evils, we will choose the necessary evil, which is less harming, though we know that it may harm. Doctor may not prescribe a person who is addicted to liquor to shun taking liquor altogether, but may prescribe a smaller dose. The golden rule of interpretation is an improvement over rule of literal interpretation. Literal interpretation is that even heavens may fall. The letter of law is the final, and you have to give the interpretation which propagates the letter of law, though the results may become disastrous. The golden rule is a rule of adaptation. That yes, we know Parliament is supreme in enacting the law, but we also know that this is reflected in the language, and we are always poor in communication. The next day we would be much better in communication. So some errors have crept in. Let us take look at the larger picture and correct the errors and move on rather than repeating the error and becoming a victim of the error. It is no prudence to live with the error. Maybe you are encroaching upon by using the golden rule, you are encroaching upon the will of the legislature, the very act of the legislature, by thinking that you can read better than what the parliament had read. You can understand better than the parliament had understood. You can explain better than the parliament has explained. We have to respect the words, but the law has to bend before justice. So rules of law can never overreach justice. Justice may be a very vague concept. It may be like amoeba. It can go into any direction, can take any shape. But yet, let us trust the people who are given that position of trust. If they feel that this is the best way of doing justice, to do a little bit departure from the language, to come out of the anomalies that have been created. I think we have appointed those persons with this trust. Let us bow to them. And if there's a room for, if we find that it does not fit into the things, there's room for approaching the next court in the hierarchy or going in review before the same court, or maybe it may go before a higher bench. So we must understand that though we have vast potential, but there are certain bottlenecks, there are speed breakers. So let's have it as such. This was brought into existence for some very noble reasons. Still, we are human beings, we may falter, but that does not mean that if my pocket has been picked up in a bus, then that should be the end of the buses on the roads from that day. Some small things may happen. We have to start living with it and find the best way. If some mistake has occurred in the system has enough resilience that it has provided room for correction of those mistakes. So let us, absolute is not possible, but we can be relatively good. We can't achieve the absolute. So that's my take on this. And thank you very much for putting the question in very coherent manner. And as said, this was the last question. But
Yes, sir.
this is not the occasion that will prevent questions from coming into our mind. Let us keep the debate alive, and we may meet next time at some other occasion.
Definitely, sir. Definitely, sir.
Thank
Thank
you.
you so much, sir, for clearing doubts with such even pins. Although the question the session cannot go long due to time restrictions, but I must conclude the session here. Now, I would like to call our HOD, sir, Dr. Vijay Kumar Yadav, sir, to have the virtual stage and speak to you.
Thank you, Avya. Am I audible to all of you, sir?
Yes, you are audible.
Yes, sir, you clearly.
So, this respectable resource person of today's and my dear student and my dear faculty members, really, sir has given very sharp questions in very sweet way to answer all the question in very beautiful word. So it was the motivational session, you can say, and now I believe कि inside sir there is a role, there is a good teacher is inside the sir which has shown us today in a very beautiful way, or having full patience to reply all the questions. Sir has listened all the questions patiently and reply point to point. That's really a very mind blowing session for today. Sir has very beautifully described the provisions of the Constitution, especially for the preamble, which empower us the legal justice, political justice, social justice. These things are already given in the Constitution. Sir has beautifully given one example of the Rameshwaram also, that how one squirrel एक गिलहरी किस तरह से जमीन में लेट लेट के वो बालू अपने ऊपर इकट्ठा कर रही थी और एक सेतु बनाने के काम में कोशिश कर रही थी. So this indication was for towards us. Sir also wants ki like this squirrel, all law students should try to contribute a small contribution in the field of law. Then we'll be able to aware the people. So we can understand that sir has a lot of burden because judges are having the top status of the judiciary. At the same time, there is certain code and conduct the judges are required to follow it. So in public platform, so many things are there which can be explained, but due to some restrictions, we can understand all these things here. So I would like to request to all the students कि they should come forward to make the people aware of their fundamental rights, their human rights. They should continue with the legal camp also to make the people aware. If laws will be able to aware the people, then half of the problem will be solved. The judiciary is facing a lot of problem. All the courts are overloaded with the cases. Fast track courts are also there, tribunals are also there, but still the numbers of cases are increasing day by day. So we can understand how these courts and judges are overloaded with so many complaints and problems. And you can also understand for taking one judgment, how our honorable judges are working and how pain they are taking to establish the faith of justice in the society. हम कभी भी लड़ाई झगड़ा करते हैं तो हम एक ही बात कहते हैं, आई विल सी यू इन द कोर्ट. क्यों कहते हैं? बिकॉज वी ट्रस्ट ऑन द कोर्ट, वी ट्रस्ट ऑन द जजेस, दोज हु आर वर्किंग इन द जुडिशियरी सिस्टम. सो दिस इज द ड्यूटी ऑफ द इंटायर लॉ स्टूडेंट टू कंट्रीब्यूट इन दिस फील्ड एंड क्रिएट अवेयरनेस अमंग द पीपल. अगर हम सब मिलकर काम करें तो आई होप वी कैन एस्टैब्लिश a very good example and everybody will be able to get their justice on time. So I'm really very much thankful to sir. Sir has managed his valuable times for us और उन्होंने लगभग 2 hours समय हमें दिए. Really I'm grateful towards sir on the behalf of institution and student. और student को भी मैं कहूँगा जो भी sir ने बताया, you try to get in your daily routine and try to devote some small contribution towards the society. थैंक यू वेरी मच, थैंक यू सर. और हम चाहेंगे सर कि आपसे एक और सेशन लें. और मुझे बड़ा अच्छा लगा, मैं समझता हूँ कि अगर आप टीचर होते हैं यहाँ लॉ स्टूडेंट में तो यू कैन कंट्रीब्यूट ए लॉट और बहुत ज़्यादा बच्चों को आप मोटिवेट कर सकते हैं. तो रियली आई एम वेरी हैप्पी एंड रियली आई एम वेरी ग्रेटफुल टू यू सर.
You are always welcome.
Yes, Abhay, please proceed.
Thank you so much, sir, for your kind words.
Thank you.
I thank our honored guest speaker, Justice Mohan Sharma, sir, once again for sparing his precious time, and our Vice Chairman, sir, who had joined earlier for this session. Hope your valuable words are a life changer for many and maybe become the fish you were aspiring us to be. Thank you so much, sir, and all those who are present here. Have a nice day. Stay safe. Signing off.
Thank you.
Thank you, sir. Thank you. Thank you very much.